Your Honour, my name is Leong, Leong, initials BM, barrister by law acting on behalf of the defendant. Today, Your Honour, there is 106 charges against my client. My client is Aboriginal, Your Honour, 14 years of age, and my client is subsequently a juvenile. The evidence the police seek to rely on, Your Honour, specifically the admission at the scene, is prejudicial. None of the information the barristers obtained, retract that, Your Honour. None of the information the police obtained at the scene from my client was recorded. No notes were taken by police officers. The police have simply drafted their own perception of the situation that occurred at the scene and put this into a statement without conferring with my client. My second argument follows, Your Honour. After arresting my client, the police drive him around the neighbouring suburbs. The arresting officer and his partner then engage in conversation with my client while driving him around. The conversation is to the effect of, "Did you break into this house there?" My client responds, "I'm not sure." The arresting officer then asks, "Did you break into this house there?" My client says, "I don't know, probably." Again, the arresting officer asks the third time, Your Honour, "Did you break into this house here?" My client responds by, "I don't know, maybe." Your Honour, this is asked 106 times and forms the basis of the claim against my client. Once back at the station, my client was placed into an interview room. In this interview room, there was an unfamiliar person, neither familiar to my client nor the defence. This person was not known at all in any way, in any capacity, as a friend or guardian. Assumedly, this is who the Crown picked to play a support role for my client. This person was unknown and proceeds to tell my client, before the interview begins, to tell the truth and answer the questions the police officers ask. I'll just repeat that, Your Honour. This unknown person proceeds to tell my client before the interview to tell the truth and answer the questions the police officer asks. At this point, Your Honour, my client had not been given the opportunity to contact a parent or guardian. Therefore, this forms the third base of my argument. At no time throughout this entire process, from time of arrest, to being driven around, to being placed in an interview room, was my client given the opportunity to contact a parent or guardian. It was evident to the police, Your Honour, that they were dealing with a juvenile Aboriginal defendant. And I say it is reasonable to assume, Your Honour, that they should be aware of the strict statutory requirements that govern such a situation. Can I now take Your Honour through the validity of my arguments, specifically the Police Powers and Responsibilities Act 2000 and the Police Powers and Responsibilities Regulation 2012. In specific, I refer to Section 420 of the Police Powers and Responsibilities Act, which states, before interviewing an Indigenous suspect who is a relevant person, the police must inform the relevant person that legal aid will be contacted and allow the person to talk to a support person. I emphasise, Your Honour, here, at this point, none of these requirements have been met. Further to this failure, I now refer to the Police Powers and Responsibilities Act, Section 421, which states, if a police officer wants to question a relevant person, and the police officer reasonably suspects the person is a child, they must take the cautions that are set out in 421 sub 2. Your Honour, it was evident my child was an Indigenous juvenile, and the police should have been aware of this. As such, 421.2 then goes on to say that in the instance a police officer reasonably suspecting the person is a relevant person and a child, the officer must not question the child unless before questioning starts, the police officer has, if practicable, allowed the child to speak to a support person chosen by the child in circumstances which the conversation will not be heard, and the support person is present while the child is being questioned. My key point on that statement, Your Honour, is chosen by the child. There is nothing to suggest the situation gives rise to an impracticability to follow the rules. My client wasn't jetting off on a plane. My client wasn't dangerous. My client wasn't threatening. Your Honour, the police allowed a conversation for my client to a support person, or with a support person. Such conversation was not overheard. However, Your Honour, they have failed that first limb of 421.2, in that my client was not allowed to choose the support person in that room. Again, let me emphasise this, Your Honour. That person was entirely unknown to my client. This unknown person did not support my client to any great extent. As a result, Your Honour, the officers have failed to lawfully abide by Queensland law, specifically Section 421 of the Police Powers and Responsibilities Act. By way of elaborating, Your Honour, I think it'd be appropriate now to guide you towards the regulations of the Act, the Police Powers and Responsibilities Regulation. Specifically, Your Honour, I guide you to Section 25 and 26. These sections govern the way in which police officers question and caution Aboriginal people. With regard to Section 25, Your Honour, it is evident on the facts of the case the police have failed to ask any preliminary questions to determine my client's level of education and understanding. Further to this, Your Honour, the police failed to caution my client at any point, giving him the knowledge that he had a right to remain silent. This right is imperative to comply with Section 26 of the regulation. As such, this goes towards the level of admissibility of my client's evidence. The ignorance of the law is evident throughout what I have just submitted, Your Honour. Ignorance throughout all parts. These sections of the law are there to be followed, Your Honour. They are clear, they are undisputed. Your Honour, I finalise my submissions by guiding you to Section 5 of the Police Powers and Responsibilities Act. Section 5 specifically states, subsection E, to ensure fairness, protect the rights of persons against whom police officers exercise powers under this Act. It is evident, Your Honour, from my submissions and what I've just brought you through, that fairness was not evident in any part of this case. From the point of pick-up and arrest, to the point of driving around, to the point of interview, at no point was there any fairness given. After consideration, Your Honour, of both the Act and the regulation, of which in this instance have been violated, I ask Your Honour to exercise the inherent jurisdiction and exclude record of interview, which as it happens is the only evidence against my client. As Your Honour is aware, as per Bunnings and Cross and the Ireland decision, Your Honour is permitted to exercise discretion to exclude such an interview from the evidence as a result of non-compliance by police officers of their legal obligations. Thank you, Your Honour.